the strong recommendation of the manufacturer of the kit that you're relying on?
Objection, assumes facts, not an evidence.
Well,
Overruled. Overruled.
It might be the strong recommendation of the manufacturer of the kit. However, the manufacturer of the kit is not a group that's engaged in routine forensic DNA typing. So,
was this kit,
I'm sorry, could the witness finish her
I
answer,
thought she
please?
had, I apologize.
so a laboratory with some experience might, like any recommendation, might decide to accept that recommendation or not accept it.
Isn't there a statement actually on the kit by the manufacturer that this kit is designed for forensic application?
That's right, but the manufacturer of the kit is not a forensic DNA lab.
To your knowledge,
I'm sorry, could the witness finish her answer, please?
I'm done.
All right.
Proceed.
isn't the kit explicitly and expressly warranted to work only if you follow the directions on the kit? Isn't that a warranty given by the manufacturer?
Yes, but that's in terms of the salt solution concentrations and the temperature and the quantitation, that is the amount of DNA you add. There's no specific directions they can give you to ensure that the rest of your handling is good or bad. They can only tell you if you have the thing at 60 degrees, it'll work, and if you don't, it won't.
So is it just, so I'm clear on this, is it your position that the express instruction from the manufacturer that you are, quote, to perform DNA extractions from samples containing high levels of DNA separately from samples containing a low level of DNA is something that the people who utilize this kit are free to ignore?
Yeah.
I'll withdraw the objection.
Yes, and I mean, what's high and what's low? I mean, this is going to be the judgment of the people in the laboratory. That's not a specific instruction. It's a vague instruction.
Granted, Dr. Cotton, what's high and what's low is something that has to be determined by the in particular laboratory, but once that assessment is made as to what is high and what is low, wouldn't you agree that it is critically important to follow the instruction that that which you consider a high level of DNA should not be extracted at the same time with that which you consider a low level of DNA?
Objection asked and answered, and I think counsel's arguing with the witness.
Overruled. We have asked this question. Again, I'll allow the question and answer one last time.
I have stated, I think, earlier that depending on how great a difference in amount of DNA you have, if it's a very great difference, then one would prefer, if you were able to know ahead of time, to deal with the large amount of DNA or evidence that had a large amount of material on it separately from the smaller amount. And that's a relative decision for any specific laboratory.
Is the manufacturer of the kit the same entity that designed the validation studies for that kit?
Well, they certainly did a lot of validation studies, but they are not the only group that did validation studies using that kit.
Now, you mentioned in terms of your testing of items in this case that one of the items you were asked to do DNA profiling was the steering wheel inside the Bronco. Is that right?
From one item of evidence from this, I don't know if there's more than one item of evidence from the steering wheel, so we had a item of evidence from the steering wheel.
Okay. And that one item of evidence was a blood swatch taken from a smear on the steering wheel. Is that correct?
That's right.
Let me get the board. Now, would you agree, Dr. Cotton, that interpreting mixed stains is a more demanding challenge to the forensic laboratory than interpreting a stain that only has a single source?
Sure.
And when you see more than two versions of a particular gene, that enables you to determine that there's more than one contributor to that stain, correct?
Yes.
However, if you see 3 or 4 versions of the gene, you can't necessarily tell whether there's been 2 contributors or 3 contributors or more contributors. Isn't that correct?
That's exactly right.
And that's one of the difficulties in interpreting mixed stains.
Yes.
And with respect to the stain removed from the steering wheel of Mr. Simpson's Bronco, your DQ alpha typing method showed the presence of 3 different alleles. Is that correct?
That's right.
And I think you said yesterday and the day before that and the day before that one should only inherit 2 versions of a gene. Isn't that correct?
Yes, except under very rare circumstances, so
All right.
we'll just assume 2.
And certainly, Dr. Cotton, each of the individuals who you typed in this case as reference samples, namely Mr. Simpson, Nicole Brown Simpson, and Ronald Goldman, each had only 2 alleles for the DQ alpha marker.
Yes.
And when you typed the DQ alpha markers, when you typed that stain on the steering wheel, you found that there were 3 separate DNA types, correct?
Yes, we did.
You found the 1.1 version of the gene present, right?
Yes.
You found the 1.2 version of the gene present, correct?
Yes.
And you found the number 4 version of that same gene present.
Yes.
And initially on this board that you saw, the prosecution had written that the only one of the 3 people not excluded was Mr. Simpson, correct?
Yes.
But I take it you did not help the prosecution prepare this exhibit board, did you?
I saw some of the boards to make sure that they were right, and I don't know if I don't remember if I saw this one. I might have.
But the reason
But there was a mistake on it.
Okay. And the reason, looking up at the top, you said that Mr. Simpson is of a... Can everyone see the top? Okay. But looking up at the top, that Mr. Simpson is a type 1.1, 1.2.
Yes, he is.
And you can see a 1.1, 1.2 in this mixture.
Yes.
And that's why he's included.
Well, and the polymarker data
Fine.
as well.
Well, actually, on the polymarker data, if you look at it, isn't every different version of every polymarker included in this mixture?
I don't remember without going back and looking.
Please take a look.
We're at 29.
29.
Okay. Yes, you're correct. There are all the possible alleles for the polymarker are present in that sample.
So in fact, if you just looked at the polymarkers and nothing else in this case, you would have to say that there'd be almost no useful information in the polymarker results because the entire human population could have contributed to that mixture.
Assuming all the intensities of the dots were, assuming the dot intensities weren't informative, and I don't recall that they are.
So the key information here in this particular case for you was not the polymarker results, but rather the DQ alpha results.
For this sample.
Yes. And not only were you able to not exclude Mr. Simpson, but you were not able to exclude Nicole Brown Simpson, isn't that right?
That's right.
And that's because Nicole Brown Simpson is a DQ alpha type 1.1, comma 1.1, right?
That's right.
Meaning that she inherited the same version of the gene from her mother and her father.
Exactly.
And so because you see the 1.1 allele present in this mixture, that 1.1 allele could simply be 2 copies of the DQ alpha typing from Nicole Brown Simpson.
Yes.
However, you in fact excluded Ronald Goldman as a contributor to this mixture, isn't that correct?
Yes, we did.
And the reason you excluded Mr. Goldman as a contributor to this mixture is that Ronald Goldman is of a type 1.3, comma 4, correct?
That's right.
And what that means is that Ronald Goldman, his DQ alpha type, has 2 alleles in it which are different from one another, correct?
That's right.
One of his alleles is the 4 allele, right?
Yes.
And one of his alleles is the 1.3 allele, correct?
Yes.
And so if this sample contained a portion of Ronald Goldman's blood or biological material, you would also expect to see the 1.3 allele and not just the 4 allele.
Yes.
And it was on the basis of that that you excluded Ronald Goldman as being one of the contributors to this mixture.
That's exactly right.
So would you agree, Dr. Cotton, that based on your analysis, that the number 4 allele that you see present in this mixture from the steering wheel must come from someone other than Mr. O.J. Simpson, Nicole Simpson Brown, and Ronald Goldman? Isn't that correct?
I would.
Now, this other person, just let me get out my diagram. Do we have the other small results?
Perhaps we ought to move that over here, because that one, height-wise, is hard to see unless it's in the middle. Flip.
I've established that.
So stipulated. All right, Mr. Neufeld, can you work with this?
Listen, given my artwork, I'm sure it'll be adequate.
All right, Mr. Scheck, Mr. Scheck, don't go away. You may need to steady that.
All right. Good. All right. You can do better than this, can't you? Only in California. All right. Dr. Cotton, now this third person who cannot be Mr. Goldman, who cannot be Nicole Brown Simpson, and who could not be Ronald Goldman, who has, we'll call him, all right, we'll call him actually the fourth person, because he's none of the three people whose reference samples you tested, all right? And this,
Objection vague.
this fourth person has the 4 allele, correct? As
Yeah.
one of his 2 or one of her 2 alleles, correct?
Well, yes, if we assume a person in there
Right.
has a 4 allele.
Okay, let's start with the most simple assumption first. All right?
Okay,
Now, this person who has the 4 allele also has 2 alleles inherited, one from his mother and one from his father, or one from her mother and one from her father, correct?
yes,
And so this person could have different possible genotypes as well, correct?
of course.
This person could be, given the presence of the 1.1 and 1.2, could have as a genotype a 1.1, comma 4, correct?
Yes,
This person could have as a... I'll move in a second, I'm sorry. This person could have as a genotype a 1.2, comma 4. Whoops. Just there for a compliment. A 1.2, comma 4, correct?
yes,
And this person could also have inherited the same version of the gene from both parents and be a 4, comma 4, correct?
yes,
Okay. And those are 3 possible explanations for a genotype for a fourth person. If the fourth person contributed the number 4 allele, correct? Those are possible
those are the
genotypes.
those are the 3 possible genotypes for a person in that mixture if that person's first allele is a 4.
Okay. Now, you take that down. Oh, what would be next in order, Your Honor?
That would be 1150.
Now, Dr. Cotton, I'm going to ask you a hypothetical. I'm going to ask you whether or not that hypothetical is consistent or inconsistent with the observed evidence in your laboratory. Assume that Mr. Simpson cut himself in his home and walked out to the Bronco to get something from his car and bled in his own Bronco.
Objection, I'm
Assu-
sorry.
Sustain.
Assume, Dr. Cotton, that some of Mr. Simpson's blood is in his own car.
Same objection, Your Honor.
So,
Overruled.
and assume, Dr. Cotton, that some other person, other than Mr. Goldman, other than Nicole Brown Simpson, other than O.J. Simpson, had come into contact with the blood of Nicole Brown Simpson, and then entered that Bronco and made a smear on the steering wheel, having touched Mr. Simpson's blood.
Same objection, Your Honor.
Sustain.
Dr. Cotton, if somebody else who is either a DNA type 4, comma 1.1, or 4, comma 1.2, or 4, comma 4, touched Mr. Simpson's blood and touched Nicole Brown Simpson's blood and touched that steering wheel, would that be consistent with the stain you
Improper
found on the
hypothetical, Your
wheel?
Honor.
Sustain. Juries to disregard the implication of the question. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves. Don't form any opinions about the case. Do not conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. Have a pleasant weekend. Enjoy the activities. See you Monday. All right, we'll stand in recess till 1:45. And previously, there had been raised a discovery, I guess, Griffin issue regarding continued testing at DOJ. And Mr. Scheck, since you raised the issue, do you want to advise the court the nature of your concerns?
I think my concerns can be simply stated. I think it's close to 2 months ago, or it's hard for me to remember, before the examinations of the criminalists began, Mr. Harmon requested to combine all the samples in the Bronco, 303, 304, 305, of which 303 and 304 being stains that were in the location originally of 30 and 31. And they took all of it, 30, 31, 303, 304, 305, after notice to the court, and asked for permission to combine them all together to do RFLP testing. I think that we all believed that they were going to commence with that soon after giving us notice.
Immediately, if not sooner.
Immediately, if not sooner. And the concern that I expressed at that time, and plainly the reason for the testing, is that there's ambiguity with respect to the test results on these combined stains in the Bronco. I think Mr. Harmon indicated, and the prosecution indicated, that they wanted to combine all these stains to do RFLP testing to get more information and greater clarity with respect to the results one way or the other, to exclude or include various individuals in terms of having greater information.
All right, well, let's assume, Mr. Scheck, what you say is true. What do you want me to do about it and why?
Well, I think that the problem is that since they have not even begun testing, and we know that the combined samples is something on the order of 72 nanograms of DNA total, I think, at best, that this particular form of RFLP testing is going to take between 4 and 7 weeks, because what's going to have to occur if they're going to get results is laying the order ads for long exposures. So this is, in my judgment, a tactical decision by the prosecution to gain an advantage in terms of possible cross-examination of the witnesses and then rebuttal case. It's just more of what I think has been going on all the way through, which we've complained about to the court from the beginning, but this I think is extreme. This is now at the point where it's very clear that this was done not in good faith, but for purposes of obtaining a forensic ambush in this trial, if that were to occur. It also precludes the defense from having any access to the samples during these periods of time if they were not going to engage in this testing. So I think it presents a discovery problem. The cases that we discussed long ago.
Well, Mr. Scheck, let me
Yeah.
redirect your thought process. Let's assume that everything you said so far is true.
Right.
What do you want me to do about it? And what's the legal basis for doing that?
The problem is the only relief at this point is preclusion. I don't know of any other real remedy for this at this point in time, by the way they've set it up.
So you want me to make, on the basis of this, you want me to make a finding of bad faith, and based upon that, preclusion of any results?
Yes.
All right. Mr. Harmon. Good afternoon, sir.
Good afternoon, Judge. Now that the jury has seen the kind of evidence we have, the ambush already happened, and the overwhelming mountain of DNA evidence has begun to cascade right where it belongs on Mr. Simpson. While it may have been intriguing and entertaining back in October or whenever these discussions happened before I started coming down here, that our tactics, our tactical decisions, precluded them access to the DNA evidence in this case. You are aware, and they are aware, that they have never gotten one of the many, many remaining swatches in this case to test for DNA typing. If they have, it's news to me, which is always possible, but I'm not aware of it. So we can cross that one off the list as a good faith argument. Nobody's precluded them access. There's a bunch of stuff over at LAPD-SID that we would love to have them test for DNA typing. So let's strike that from our agenda. Practically speaking, although no objection has been made, Mr. Sims is going to have to come back after this chunk of his testimony, because there are tests specifically on 117 that have been going on for quite some time that haven't been reported. And while Mr. Scheck hasn't objected to me presenting, if he doesn't mind me objecting to having Mr. Sims present them when he testifies, hopefully next week, even though he hasn't gotten the reports, but he knows what the results are, I'll be happy to do that. I'd like to finish him in one session. But I know it's not fair, because we don't have a report. And so Mr. Sims
One session or one sitting?
I misspoke there. One lifetime, maybe.
God, you got my hopes up.
Mr. Scheck, as part of this bad faith, said, I wrote this down, they have not even begun testing. And I'm as shocked to hear that as I'm sure Mr. Sims is. They've begun testing. They just haven't begun the part of the testing that he's dying to know if the other shoe is going to drop out of. So the testing has begun. Mr. Sims has a life. The DOJ lab has a life independent of this case. You know, aside from those are my normal comments that have nothing to do with the legal issues. There is no legal issue that allows them to do what they've asked you to do here. They have consistently whipsawed the defendant's right to a speedy trial and said, but this isn't fair, we're never going to know. And if they'd waited, they would have known all this ahead of time and maybe rethought their tactics in this case as the DNA test unfolded. But the fact of the matter is, they chose when to go to trial. And we have done fairly well. No case has ever had the amount of DNA evidence analyzed as has this case. So I think the court realizes that at this point, the arguments that we have precluded them access, or this will continue to preclude them access to evidence, when, except for the intriguing 47, 50, and 78 that weren't done for DNA testing, they've never done any DNA testing on any of the evidence. That's not a sincere argument. But there's simply no legal basis for it. I wish we were done. Mr. Sims wishes he was done. Unfortunately, once you step out of this courtroom and out of this building, there's a whole world and a life out there, and everybody has to balance, except for us, everybody has to balance that, and we're just stuck in this for the time being. So there's no legal basis. If they'd hurry up with their cross-examination of witnesses, maybe we wouldn't get around to testing it, and there wouldn't be any ambush. But, you know, the lengthy cross-examination that we saw in April just makes it easier to finally get around to the last set of tests, and that's about the last set of tests. So if they were concerned about it, maybe they should have cut off some of their cross-examination and precluded us from practically being able to get to these results. Thank you.
Mr. Harmon, when did the actual combined RFLP testing begin?
Mr. What's your name? Clarke has a recollection that it was April 3rd. Mr. Sims is, could I ask him? He's got his notes here. I just didn't bring them here. Because we had those discussions, and I can tell you that things have been done towards the typing.
All right,
but
the record should reflect that present in the audience is Gary Sims, Department of Justice. Good afternoon, Mr. Sims.
Good afternoon.
Do you have your notes regarding the commencement of that RFLP testing?
Yes, I do.
All right. Can you tell me the date? All right.
I think also, Your Honor, can I just speak from...
I would welcome him to define it. I'm only going on based on what Mr. Harmon told me and
Certainly.
everything else, and the original source is Mr. Sims, and I welcome any remarks. I'm sure that they're completely accurate.
I remember at first there was a legal hurdle we had to overcome, and there was a declaration in which I said that I would save swatches, which I did. And I don't remember the exact date of that declaration. And then that was litigated. And then the samples came back up to us, it looks like on March 9th. March 9th was when we started, we got some of those samples back that we wanted to do the additional testing on. And the actual completion of the test that we did through the extraction, we did some DQ alpha typing, et cetera on those, and that, including quantitation and some other things, and that was completed about early April. So since sometime in early April, I did.
Can you pin it down a little closer than early April? And Mrs. Robertson, could you find the motion with regards to the prosecution's motion to for permission to combine those items for testing? And the declaration by Mr. Sims should give me some idea as to where we are.
No, I don't think we
Hold
filed
on.
a formal motion.
Your Honor,
There was a declaration.
the note I had would be April 4th. My
April.
notes say, this is on page 239 of my lab notes, April 4th, 95, DNA 30, 52, 53, that's those three combined samples, proceed to RFLP. So, April 4th.
April 4. And Mr. Sims, when do you anticipate having final results and completing the report as to that test?
For that particular sample, it may be that we can only get a few probes off. So we may have to go with just some partial information as far as the probes that we can see.
All right, when do you anticipate knowing the results?
The process itself takes several days as far as restriction, gel, blotting, and then we'll also, of course, have to have the probing done. So I would think we've probably got maybe a month and a half of work, something like that.
Still to go?
Yes, maybe 2.
Are we going to be done by then? That was my hope.
Well, we may have preclusion by passage of time. All right, Mr. Sims, do you happen to have in your case notes there a copy of your declaration?
I don't think I do, Your Honor.
All right, then I'll have the clerk find that. I just want to get the declaration so I can place our legal discussions in context, time-wise. All right, Mr. Scheck, any other comments?
Yes, just one. I just note for the record that I don't want to violate any of the court's rules with respect to making comments. I'm trying very hard, and Mr. Harmon has a very colorful way of expressing himself, and I'm not amused. And I will not take the bait of answering all these things, but I want the court to know I'm not amused. There's one thing that does require note. Once again, Mr. Harmon is making statements about what he knows the defense did or did not do in secret testing. That motion is still before the court. That record is still before the court. I don't think those are proper comments. I don't know how he knows any of this, and I'm very concerned about it. And I would call the court's attention, I will file a letter memo on Monday, to the case of County of Los Angeles versus Superior Court at 222 Calap 3rd 647. Since it's my opinion, if the court consults that authority, that Mr. Harmon's previous admissions in our discussions of his efforts to find out about privileged communications and testing, if any is done by the defense, already by his own admissions, is unethical, violates rules, and actually merits the sanction of recusal from the case. I haven't said we're going to ask for that with respect to Mr. Harmon, but it's serious, and I don't think he seems to understand that. And he did it again today.
All right, thank you, counsel. What I will need to do is review the record with Mrs. Robertson to determine the actual dates of the declaration filed by Mr. Sims, and then rule after I have that information available to me. Mr. Clarke, you mentioned something earlier this morning that we needed to resolve. Clarke, that's you.
Actually, I wasn't looking to remember who I was.
All right.
I'm trying to recall what we had left. I thought.
Do you want to do a schedule? Oh. Dr. Weir's memo?
All right, anything we need to do on Mr. Blazer? You're raising the issue regarding
Yeah,
Dr. Weir's...
mixed sample calculations. Mr. Thompson is prepared to present our position on that.
All right.
If they're ready to talk about this.
I thought we were going to go through this phase with Dr. Cotton, and then she was going to have to return anyway because of the court sustaining the objection as to foundation on, for instance, frequency calculations, including the Department of Justice, as well as there are some other issues that relate to results from the Department of Justice that I was going to ask Dr. Cotton about. So I may have been under the wrong...
All right, so you were not anticipating presenting this until Robin Cotton round 2?
Exactly, because there is a number of pieces of information that need to be looked at as far as to calculate these frequencies. This was done in very much a rush. And frankly, I don't think it's been too fast to be able to present this information properly and to calculate it properly. So Dr. Cotton is still working with Dr. Weir to be able to calculate those frequencies. I'm not trying to give the court the impression we don't plan on doing that, we do. But it's not as simple as taking a few days to calculate as it's turned out.
All right.
Well, Your Honor, two things. One is,
Well, wait, who's going to address the issue? Mr. Thompson,
Well,
Mr. Blazer, Mr. Neufeld?
no. Professor Thompson was going to address the actual numbers that were presented by the prosecution in a memo written by Dr. Bruce Ware. All I wanted to do is remind the court on a preliminary level, procedurally, that it was your ruling, not that they were going to wait and present numbers at some other occasion on some other date, if and when Dr. Cotton returns to court. It was the court's ruling that they were compelled to produce some number which aggregates the respective frequencies in the population of all those people who are not excluded. And the issue was not whether they use a product rule or a ceiling principle. They can use whichever one of those numbers that they deem appropriate given the outcome of the Fry issue here, but that they had to produce a number. And that it was decided by agreement, I believe, at a sidebar, that the way it would be done, since we couldn't conclude that issue on what the number was before I commenced cross-examination, that he would be permitted, while Dr. Cotton was here these couple of days, to reopen his direct examination just for that limited purpose. And so he would either do it as a reopen or he would do it during the course of redirect. And what I said is, and he agreed at that point, is I was not going to comment on his failure of presenting those numbers during the direct.
Well, here's the other problem, though. We know the scheduling problems that we have with Dr. Cotton. We know now Mr. Clarke is indicating to me that he's not ready to present these numbers. I can't force him at this point. If he wishes to recall a witness during the course of his case in chief, he's entitled to do that.
1 second. What I would ask to be able to do at this point, Your Honor, if that's the court's feeling about this, I mean, frankly, in terms of scheduling, I don't think it's a big problem. As I informed the court earlier today, I will finish my cross-examination on Monday, and now I've actually said it on the record in open court as well, so it's no longer a confidential matter, but I do make that representation. And she has to finish by Wednesday, I believe, with her schedule. So certainly, that's more than enough time for redirect, as well as to handle any anticipated problem with these numbers. And I think it's...
Well, let's see where we are. Mr. Clarke, when are you going to have your final numbers calculation? When do you think?
I don't know the answer to that. It's a much more complex task than it might seem on its face. And the two of them are working together quite a bit, I mean, intensively in the time that's been available over the last few days. I can ask Dr. Cotton how long she anticipates that would take. But I don't want to be in the position of having to produce all of a sudden a frequency that's the product of rushing, and then all of a sudden it's attacked because it was forced, it was compelled to be done, and it wasn't examined sufficiently. So whether under a misapprehension or not, I think the additional time will help ensure the accuracy of those numbers, but I'll be glad to ask Dr. Cotton how long she anticipates is needed.
All right. How long will it take you to contact Dr. Cotton? Can you do it right now?
I believe so.
Okay.
Just want to remind the court, Your Honor, of one other thing. It was a week ago that you had asked Mr. Clarke to have those numbers ready just in case that was your ruling. So they've had a week to prepare those numbers in anticipation of the court's ruling. So it's not something that was a rush to judgment, if you will. It's something where they had plenty of time to process it. And, in all due respect to what's involved here, I don't believe, for instance, with item 29, for instance, it takes days or weeks or even hours to answer the question that's posed in the National Academy of Science NRC report, which is simply aggregating the frequencies of that portion of the community that can't be excluded.
All right. Let's take 5 minutes, and Mr. Clarke, why don't you give Dr. Cotton a call, and let's see when we might anticipate, because I'd like to wrap that aspect of it up this round if we can.
Very well.
Okay.
Your Honor,
Right.
but may I be heard
On what?
on something unrelated to this?
All right.
Maybe just to set as time
Yeah,
for
Mr.
scheduling, because I noticed Mr. Cochran's not here and Mr. Douglas is not here. This morning, the prosecution was provided with some additional discovery and a supplemental defense witness list which includes about a dozen new names. For a few of these people, the discovery which was provided is just in the nature of rough notes which are incomprehensible. There are no dates of allegations. That apparently they contain allegations. We can glean that much. But this is incomplete discovery, and it's brought up to the fore a problem we've been wanting to address for a while in terms of incomplete defense discovery. And that is that on the combined defense witness list, there's over 50 people still on their witness list, excluding American Airlines passengers on the flight to Chicago, which is quite a few people by itself. Excluding that, there's still over 50 people on their witness list for whom they have not provided discovery, and we never initially provided discovery to them. So while there are a number of witnesses that we can kind of glean the nature of what they'd be testifying to based on discovery we provided to them earlier at a point in time, such as some of the police officers, there are quite a few witnesses that we've never heard of and we know nothing about. And it's becoming difficult to believe that there has not been defense investigation culminating in some kind of statements from these witnesses. So I have a list of those. I was hoping Mr. Douglas would be present this afternoon so that I could ask him about it. Perhaps I could lodge that list with the court and fax a copy to the defense, because it's certainly getting to the point where we're getting very close to the defense case and we don't have discovery on a lot of their supposed witnesses. Maybe they're people who they are going to be taking off their witness list, but if that's the case, they should be doing that.
All right, once you lodge your list with the court, send a letter to fax a letter to Mr. Douglas this afternoon, advise him of your concerns, and if it's necessary, we'll set it for a hearing.
All right, thank you, Your Honor.
All right. Okay, let's take a 5-minute recess. Mr. Clarke, why don't you chat with Dr. Cotton?
Your Honor. What?
I think we do have to approach at least one item with respect to those numbers, though, in terms of what's going to happen in court. I don't think there's a problem with the PCR markers. Dr. Cotton testified that that method, in fact, can be used of summing up these various genotype frequencies. As to the RFLP results, that is the mixture on the boot stain, item number 78, they don't believe, that is, Dr. Cotton doesn't believe it's appropriate to assign a frequency. It can be done, but I hope the court isn't under the impression that when she testifies about numbers as to that particular item, that in fact she's going to represent that as this is an appropriate way to do it in the face of what I anticipate is going to be a defense attack on those numbers. So it's a difficult situation at best, and perhaps the defense can tell us what number they would like to see attached, for instance, to that mixture on item number 78, and perhaps we can agree to it.
Your Honor, the problem is, which is what the NRC report says, and which the court accepted, is that you can't present the DNA evidence of a match or even a consistency without a probability. If the people feel that they cannot produce a number for those items, then they had no business producing the suggestion that there's a match in the first place. That's what the scientific community says, that's what the law is in the state of California, and that's what should have happened here. And to that extent, Your Honor, I believe that, it isn't fair on a very fundamental level. If they have a number that they intend to introduce for each of these items, we'd like to hear the number, obviously, outside the presence of the jury first, so we can at least question it, because frankly, if it's a number just pulled out of thin air, obviously it would be inadmissible, and there may be other grounds for precluding that number and compelling them to go back to the drawing board to produce another number. But I am somewhat concerned, that being the law, and you making a decision beforehand that before they could actually testify to a match or a consistency, or however you want to describe it, for item number 78, that they didn't have a number that they could put forward with that other expert opinion. And that raises some very, very serious questions. That's all I'm saying at this point.
All right.
So we'll have to address it Monday morning, but there may be a need to strike that portion of the testimony or give other curative instructions.
Let's see the number. Let's wait till you see the numbers, see what you think, and if we can go forward, we will. And if we need to have a hearing out of the presence of the jury, we will.
Right. One other matter, Your Honor.
Because don't forget, we don't get to that point until Mr. Clarke has the opportunity to reopen, to represent. All right?
Oh, sure.
Okay.
I agree. Well,
Right.
all right. One other matter, Your Honor. I
So it
believe,
looks to me like 4:30 Monday, we may get to this.
hopefully earlier. It may surprise you. One other item. Carl Douglas brought to the court's attention earlier today a matter involving a representation that had been made on the record yesterday, suggesting that Mr. Simpson, when he was arrested, had thousands of dollars either on his person or in his bag. And Mr. Douglas brought that to the attention of the court because we had never received any discovery and we had no information to support that wild accusation. I think we have now learned, or we will hear from the district attorney, hopefully, that in fact that accusation that was made yesterday had no basis in fact to support it, was not correct. And what concerns the defense, Your Honor, is again, and it has happened before, of an instance where certain statements are made on the record, not in front of the jury, obviously, because they're not hearing this, but to another jury. And we just would like the court to be very careful that if this kind of thing happens in the future, that some type of corrective measure should be taken by the court. That's all.
Ms. Lewis, do you want to address this for the people?
Yes, Your Honor. During the course of the argument in favor of our calling Mr. Kardashian to the stand, I said that I believed that within the black bag was several $1,000s along with the gun and the disguise. Apparently, and I was in error in believing that the money was inside the black bag. It was on Mr. Cowling's person, some $8,000 to $10,000, and I'm informed it was returned to Mr. Cowling's. So it was within the Bronco, but not within the black bag. And I don't mean to have misled the court in any manner. That was an offhand remark that wasn't germane to the motion we were discussing.
All right. Mr. Clarke, when do you anticipate that Dr. Cotton will have this calculation available? You said Monday, but is there a possibility that could be faxed to counsel earlier so that they can have some opportunity to evaluate it, so maybe we can cut to the chase on Monday?
Yes, I'll obtain Mr. Neufeld's fax number and we'll fax it as soon as we can.
Terrific. Okay, appreciate that. And let's see, then the only thing remains is for the court to evaluate Mr. Sims' declaration and see if there's any problem there. But I see this as a premature objection at this point. All right.
Mr. Sims pointed out one thing with respect to that. I'm pretty sure it's in the declaration, and Mr. Scheck, I'm sure, will clarify how he misspoke on the point. All of those samples were not consumed at that time.
I don't think, how could he have consumed them? He hasn't done the tests.
Well, you'll see what, I mean, he said they were all consumed, that's my recollection, and
Whatever, I'm only going on what they tell me, and I brought it to the court's attention because I was concerned that the testing hadn't begun.
All right, I'll note the objection, I'll evaluate the declaration. At this point, though, I think the objection's premature. All right.
We'll try to get it this afternoon, and I'll get it to the court this afternoon, they're trying to get it now.
Fine. Okay, then I could spend the rest of the afternoon working on the other rulings I need to make.
Thank you, Your Honor.
Can't
All
wait,
right.
we can't wait.
Not like I haven't been busy. All right, we'll stand in recess, 9 o'clock. Thank you, counsel.